Okay. Okay. Officer, I think Officer Green said that he's going to get some more people in front of the camera for you guys to interview, and then he stepped away, so I didn't get a chance to tell him who we have matches for just yet. So when he pops back in, I'll let him know what we have ready to go.
Good morning, Your Honor.
Good morning, ma'am. Happy Monday.
Happy Monday.
Okay, here's what we have for people. MIDC attorney is here. He's given us names for people for whom they have interviews, and we have files. They have more interviews done, but we don't have files yet. But here's what we have matches for. Let me know when you're ready.
I'm ready.
Eric Dancy. Ishmael Navarro. DeAndre Ellis. And on the women's side, we have Sylvia Nevins. Be advised, we have files, but no interviews yet for Eddie, looks like Range, R-A-N-G-E, and Melvin Burnett. We have files, but we have those two files, but we don't have, I'm sorry. You know what? Disregard. Those are both disregard. Those are both Wayne County Jail. Disregard. So what we have for you is Dancy, Navarro, Ellis, and on the women's side, Nevins. And we're just waiting for more files to come. But and actually, I'm going to turn it over to counsel because he can give you the names for interviews that they've done. We're just waiting for files. Counsel, when you're ready.
Yes. I have Walter Dancy, Sylvia Nevins, Ishmael Navarro, DeAndre Ellis, Demetria Edwards, Angela Waller, Deshaun Smith, Brandon Childs, Anthony Jackson, Michelle Allen, Anthony Rojas, Clinton Howard, Chioki Funches, and Shantez Neal. And if you have a list, it's number 3 to 16.
Copy. I have one.
Yes, sir.
Hello.
Hello. Right here.
Oh, I'm sorry.
She stepped away for a second.
Okay. Hi, sir. Stand by. Your attorney just came back into the room, so we're going to get your name. Your name, sir?
Walter Dancy.
Thank you. We're on the record. Okay, so you said your name is Walter Dancy, is that correct?
Yes, ma'am.
Okay, thank you. Stand by, we're on the record. Calling case number 8218707900301, People State of Michigan versus defendant number 1, Walter Eugene Dancy. Counsel.
Brian Murat, PA 3665, on behalf of Mr. Walter Dancy, lead brief, stand mute. Mr. Dancy has been advised of his constitutional rights.
Await the formal reading, enter a not guilty plea on your client's behalf. There is a Zoom pretrial date, stand by, set for May 7, 2021 at 8:30 a.m. at the 36th District Court, and this will be in front of Judge Bryant. And as to bond.
As to bond, Your Honor, Mr. Dancy is a 42-year-old lifetime resident in the city of Detroit, has earned his GED. He's not on probation or parole, Your Honor. He has a stable residence in the community with a cousin as well. I do understand that this matter is caseous. Mr. Dancy did indicate that he was not aware. Our office did take the liberty to explain to him how to log on to Zoom and to expect an oncoming court date. So we are confident that he will appear to his next proceeding and follow this court's order, specifically the no contact order as well. We're asking the court respectfully for a personal bond, Your Honor.
Thank you. And did you see as a bond, are there any holds?
No holds, Your Honor.
Okay, thank you, counsel. Thank you for proactively addressing what was in the file. A capious, a review of the file notes that on June 12 of 2018, your client failed to appear for arraignment, at which time a capious was issued in bond same amount of $2,000 cash surety. Now, since then, this court is now also facing considering for bond purposes the pandemic facing the nation at this time, which and your client's failure to appear precedes that. So, and also this court does have authorization from Judge Bryan's courtroom with regard to using its discretion to set aside capiouses, given that you have, again, your office has proactively addressed and emphasized to your client that he's going to need to utilize Zoom in order to make it for his next court date. And I'm sorry if you hadn't already indicated what ties, if anything, or what are his ties to the community?
Yes, he's a lifetime resident in the state of Michigan. He has a stable residence in the community with his cousin as well. He has earned a GED, and at this time, Your Honor, is receiving government assistance at his address. So that makes me confident that he's not leaving anytime soon.
Thank you. All right, counsel, court takes all of those factors into account, including, again, the pandemic facing the nation. Also, this is an older matter, and it doesn't appear there's anything else outstanding regarding your client. Given those elements, the court is going to use its discretion, set bond amount of $2,500 personal bond, also because of the type of case it is, and it does remain open and pending. While the case is pending, your clients have no contact with the complaining witness, Kevin Miller. No contact means no written or verbal communication with this person, no messages to him through third parties, and no contact order extends to the place of residence and place of employment, and no social media contacts directly or indirectly. Is there anything further, sir?
Your Honor, I know you already said that. Can you tell me that court date one more time?
I'm sorry, May 7, 2021, and it will be in front of Judge Bryant. Is there anything further?
Nothing further. Thanks, Your Honor.
Okay, thank you. You're all set, so you can step away from the camera.
Good point, brother. Thank you.
Let me see if this man was wet, man.
Navarro.
What was you at, man?
I was in 21.
Good stuff. Navarro, brother.
Man, after you go in there, you gotta go get your COVID done, okay? Step on the line. Straight down the list.
Hi, your name, sir?
Yeah. This is Samuel Navarro.
Okay, calling case number 2005769, People Say Michigan versus Ismael Navarro. Counsel.
Brian Murad, PA 3665, on behalf of Mr. Ismael Navarro, laboring and you, Mr. Navarro, for the month of constitutional rights.
Call away the formal reading, enter not guilty plea on your client's behalf. There's going to be, well, counsel, let's address a couple of things. Let the record reflect this is a felony matter. It was originally set for preliminary exam in front of Judge King. A review of the file shows that your client failed to appear for his preliminary exam, at which time a capious was issued in bond same amount of $20,000 cash surety with Judge King on March 31st of this year. Before we address dates or bond issues, let's deal with that because your client capious, and also it is the case that within the exam judges specifically, and including Judge King, his directive is that in the event of a capious, that he would prefer to give this court authorization. There's no blanket authorization. So let's address that before we get to dates.
That is correct, Your Honor. My notes do reflect that Attorney Elizabeth Young is on this matter. Our office has yet to get in touch with Judge King. So I understand that like we said in the bond, it was already set, giving it authority. So I'm asking the court for a reasonable bond, if not personal, Your Honor, understanding the court's authority. Our office will be making touch with Judge King, and I'd ask to be allowed to recall this matter if we do so.
So noted, thank you, and we can certainly do that. DDC, in the meantime, are there any holds?
Yes, holds, Your Honor.
Okay, thank you. Counsel, here's what we're going to do again for the reasons that the court indicated on the record at this time and one, not only for the original basis of the charges, which are very serious, plus your client is facing an habitual offender third offense notice. Further review of the file indicates that when your client was originally arraigned on this case, my colleague, Magistrate Boyer, set a $50,000 10% bond, and for whatever reason your client failed to appear. So at least at some point he was clearly aware that he was due in court for another court date, and was and at some point presumptively released on bond, or a bond was set. So either your client made the bond or for whatever reason was released but failed to appear. So here's what the court is going to do for all of those elements, and unless or until we hear back from Judge King's courtroom, at this time, court is going to set aside the warrant but continue the bond in the amount of $20,000 cash surety. Also, let the record reflect there's a Zoom probable cause conference date April 20, 2021 at 8:30 a.m. to 36th District Court, followed by a new preliminary examination date April 27, 2021 at 9 o'clock at the 36th District Court, and it remains in front of Judge King. Was there anything further that you wanted to address in terms of bond until we either revisit this? Counsel?
Your Honor, I would just ask the court, ask BBC to mark his file medical. My experience is that he is in need of some medical attention.
So noted. Did you see, if you would please mark the file medical, and the court will do the same on the minimus. Is there anything further? Okay, thank you, counsel, for highlighting that. DDC, I think that's everything for this gentleman. You're all set, sir. You can step away from the camera.
Happy.
Yes, ma'am. And counsel, I'm gonna leave the other minimus in the file, but basically we filled out the one for the cash at this time. I want to say no, it doesn't sound familiar. We do not, no, sir.
Your Honor, I have a date in Taylor now as well.
You said okay. All right, I'm gonna mark it on the list because we're still getting files in, but I have a note. Hi, your name, sir?
My name is DeAndre Ellis. How you doing, man?
Okay, yeah, keep your mask on, sir. That's for your safety while you're there. All right, Mr. Ellis, before we get to your matter with your attorney present, you do have a traffic misdemeanor that we need to cover. We're going to get a new court date for you on that. Also, when you do attend these court dates for the traffic misdemeanor, it's going to be by Zoom, which is the video teleconferencing technology that we're using today. You're going to receive instructions on how to dial in for your court date, and you do need to keep coming back for all of your court dates until your judge tells you that you're done with the case, okay?
Yes, ma'am.
Okay, thank you. Calling case number P1086087, People State Michigan versus DeAndre Laurent Ellis. So you're charged with misdemeanor counts 1 and 2, driver's license expired, and no insurance misdemeanor. You missed a court date on the ticket. There's going to be a personal bond, no dollar amount listed. Court will set aside the warrant. There's a Zoom pre-trial date, May 14, 2021 at 8:30 a.m. to 36th District Court in front of Judge Ford. With any criminal matters, sir, you have the right to remain silent. Anything you say orally, sir?
I'm sorry, I didn't mean to cut you off, but I do have insurance.
Okay, sir, well then what you want, okay, here's the thing, sir, then what you want to do is make sure that you have that with you when you get to your next court date, and your judge is going to ask you about it, okay? It's just that right now, because of the way the ticket is written, it has to get set for a court date, okay?
Thank you.
Okay, so it's very good that you have it, but you want to make sure that you have proof of that for your next court date. This is going to be a Zoom pre-trial date, May 14, 2021 at 8:30 a.m. to 36th District Court in front of Judge Ford. With any criminal matter, sir, you have the right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You also have the right to an attorney. If you cannot afford one on your own, the court will appoint one for you at public expense. Do you understand these rights?
Yes, ma'am.
All right, at this time the warrant is set aside and the bond is continued. Moving on to your other case. Case number 200577865, People State of Michigan versus DeAndre Ellis. Counsel, your appearance, please.
Ryan Moronti, 3665, on behalf of Mr. DeAndre Ellis, who will be reading until 10 views. Mr. Ellis has been advised of counsel.
Okay, thank you. Stand by. All right, court will waive the formal reading, enter a not guilty plea on your client's behalf. Stand by. Court needs to review the file because it appears that your client missed a court date. So I think we're going to, before we set dates, we're going to need to address
That is correct.
bond, the capias. Court's going to look at the file. It appears that on January 19 of this year, your client failed to appear for a preliminary examination date, at which time Judge Giles issued a capias to set bond the amount of $30,000 cash. If you would please, if your office is prepared to address the issue of the capias and in the court and bond.
Yes, Your Honor. Well, I'd like to address the capias first. Mr. Ellis was arraigned on June 15, 2020, where he was given a $20,010% bond. It was a conference at June 23rd. However, June 23rd, there was a water main break, so the court was closed and that was adjourned on the 24th. Now, on the 24th, The ROA reflects that the PCC was further adjourned to August 31st, 2020 by the court due to the COVID shutdown. I believe on the 30th of August 2020, Your Honor, a PCC was held. The client's presence was waived by his attorney, Leland Mitchell, who my client indicates that did not get in touch with him. His exam, his first exam was 17, and there was a habeas issue. Now, my client does indicate, Your Honor, that he has screenshots from his phone. He's been trying to call the court, call his attorney. He was homeless, was sick for approximately 3 months. He changed his address. He did not receive any court papers. However, he did indicate that he was trying to call the district court and couldn't get through to anyone. Now, I understand the court's position, specifically the court's authority. Our office has not received an approval from Judge Giles at this time to change the bond. With respect to Mr. Ellis, he's 21 years old, a lifetime resident here in the state of Michigan, who indicates that he has no prior criminal history whatsoever, and unfortunately does suffer from bronchitis and takes breathing treatments when needed. He has a stable residence with his mother, his children's mother, and their children. So I understand we're here. We still ask for the court to find the
Thank you. And did you see at the bottom, are there any holds?
No, John.
Okay, thank you. Counsel, and again, the court does appreciate what is a very thorough recitation of the timeline leading up to his appearance today. And again, the court is bound by Judge Giles and whether or not if he's going to give authorization to this court to make any changes or amendments. And the court does appreciate you making a thorough record so that at least it's available for review in the future. And of course, if it is the case that your office does hear from Judge Giles and he makes a decision, as to what, if anything, to do with amending the bond or any changes to the bond or conditions of bond, the court is clearly available throughout the course of the day, really at any time, to address the issue of bond. Also, in the meantime, the court is going to continue the bond at $30,000 cash surety at this time with the date of April 20, 2021 at 8:30 a.m. to Thursday District Court for probable cause, with the Zoom preliminary examination date April 27, 2021 at 9 o'clock. And again, it's in front of Judge Giles, and this court is prepared to readdress the issue of bond should the need arise. We are going to keep the personal bond minimus in the file, but at this time it's $30,000 cash with the dates as indicated. The court has also marked the file medical with regard to a pre-existing condition. Anything further? Okay, you're all set, so you can step away from the camera. Okay, we don't have any other files just yet, so I'm going to get this attorney checked in, and we'll get an update as soon as we can. Hi, counsel. Hi, counsel. Are you checking in on a case?
I am, Your Honor, for Shantaz Connor.
Okay. Right, your person is on our list. It's just that we don't have a file just yet. We're still getting files coming in on a consistent basis. Could you give us your name one more time, counsel?
Certainly. First name Paul, last name Talenda, T-Y-L-E-N-D-A.
Talenda. And what is your P number?
72495.
Okay, thank you.
I'll just stand by in the room until you're ready, Your Honor.
Okay, thank you. We appreciate you, sir. And again, as we get files coming in, we'll get you an update.
Thank you so much. I'll be here. I'll keep my audio on. I'll turn my video off.
Thank you. Your name again? I'm sorry. Okay, counsel, we're informed the files are on their way into the room, so we'll get you an update as soon as we got our hands on them.
Thank you so much.
Okay, hi, your name, sir?
Demetrius Ricks.
Okay, stand by. Okay, say DDC, stand by. We're waiting for. We actually have more files coming into the room any moment now. So as soon as we have the gentleman, his file, we'll get you an update as soon as it's available.
No hands at all.
time.
There you go. So the other day, Saturday morning, I come in, I start my interviews, I can't find a book. The court book. I looked everywhere, couldn't find it. Told her, I'm like, I don't have a book. I don't have the court book. I don't know where it's at. She's like, well, just use one book. Okay, you came in, but I'm doing, you know, I wasn't here the last 3 days. But where the court book's at, I have no idea. I wasn't here. I just want to make you know it. I want you to know it. How long is it? There's no. Well, then I come in Sunday. The book's up here, not sitting on the thing. So where the fuck it came from? But I mean, look.
What a man. Okay, for all of our folks checked in, we do have the following updates. We now have a file for Shantez Neal. We have a file for Anthony Jackson, file for Brandon Childs, file for Demetrius Fritz. And I think, Mr. Fritz, you're our person. You're the gentleman in front of us right now. Okay, stand by. Okay, your attorney's here. Stand by one moment. Okay, we're ready. Calling. Okay, Mr. Fritz, you have a couple of matters that we're going to be addressing at this time. The first of which is going to be a batch of traffic misdemeanors. We're going to cover those first before we get to the case with your attorney. With these traffic misdemeanors, these are cases in which you fail to appear for court. So at this time, we're going to set aside the warrant. We're going to get you a new court date. And when you do check in for this new court date, it's going to be by Zoom, which is video teleconferencing technology that we're using today. You're going to receive instructions on how to dial in for your court date with your judge. Do you understand?
Yes.
Okay, and also when you do attend these court dates, you need to keep coming back for these cases until your judge tells you that you're done with these cases. Do you understand?
Yes, ma'am.
Okay, calling case number 518587, People State, Michigan versus Demetrius Fritz. Mr. Fritz, you are charged with misdemeanor count 1, no operator's license on person. You missed a court date. It's going to be a personal bond, no dollar amount listed. You ticket 393-40317. You're charged with possession of violation of controlled substance act. It's a misdemeanor. Personal bond, no dollar amount listed. Case number P550023. You're charged with counts 1 and 2. Looks like counts 1 and 2 only, but let the record reflect there are three misdemeanor matters on the ticket. Count 1 is for driver license suspended. Count 2 is no insurance misdemeanor. Count 3 is listed as a misdemeanor for driving unregistered or entitled vehicle. As to counts 1 and 2, there is a personal bond, no dollar amount listed. Case number 12524-544. You are charged with driver license not valid to personal bond, no dollar amount listed. These tickets are misdemeanors. The penalty that you could receive is 93 days in jail and or a $500 fine. Do you understand the charges that were read and the penalty you could receive on the tickets?
Yes.
Okay, entering not guilty on your behalf. There is, with any criminal matter, sir, you have the right to remain silent. Anything that you say can and will be used against you in a court of law. You also have the right to an attorney. If you cannot afford one on your own, the court will appoint one for you at public expense. Do you understand these rights?
Yes.
Okay, and it is the case that with each of these, you have a Zoom pretrial date, May 10, 2021, in front of Judge Sabri. The warrants are set aside and the bond is continued. And I'm going to get to your other case in just a moment. Okay, calling case number 19044 versus Demetrius Fritz. Counsel, your appearance.
Brian Baraki, 3665 on behalf of Demetrius Fritz. We agree
With formal reading and turn not guilty plea on your client's behalf, there is a Zoom pretrial date May 7, 2023 at 8:30 a.m. to 30th District Court in front of Judge Bryant and as to bond
Yes, Your Honor, I do understand that there may have been a case in this matter. My client indicates that he may have been incarcerated on a non-assault charge in Warren City. That's why he believes he had business day. As actually immunity, he's a 30-year-old lifetime resident here in the state of Michigan. Your Honor, he's going to be residing with his mother while this matter is pending, not a complaining witness. He actually has 12 children. He's certified. He's earned a certified trade in building, not on any probation or parole, Your Honor. I would ask the court to consider a personal bond in this case.
Okay, thank you. Did you see his bond? Are there any holds?
He has one hold, Your Honor.
Thank you. Counsel Court does take into account your representations between your client's significant family residential ties, as well as him availing himself of job training opportunities in the community. Also, let the record reflect that a review of the file shows that on July 8 of 2019, and the court does note that this was prior to the pandemic, your client missed a pretrial date, at which time a capias was issued by Judge King in amount of $1,000 cash surety. This matter is now in front of Judge Bryant, and Judge Bryant has given this court authorization to make changes at his discretion with regard to bond, with regard to capias bonds. Given your representations, court is confident that your client will return to court, and he'll have an opportunity to get this case in his rearview mirror because it's to his advantage to be able to do so. Court will do the following. Court finds that there's a basis to set aside that original capias bond and set bond in the amount of $7,500 personal bond. But again, because of the type of case, while the case is pending, no contact with complaining witnesses, Lamari Smith and Brenda Smith. No contact means no written or verbal communication with these individuals, no messages to them through third parties, and no contact order also extends to their places of residence and places of employment, and no social media contacts directly or indirectly. Is there anything further?
Nothing further this time.
And you're all set, so you can step away from the camera. DDC, and if we hadn't covered it already, I'm sorry, we do have new files sent. We do have the following additional files available. Let me know when you're ready.
I'm ready.
We now have files for Shantez Neal. We have a file for Anthony Jackson and a file for Brandon Childs.
Copy.
That was the first one was? You said Neil, right? The Neil's gone in.
Hi, your name, sir?
Shantez Neil.
Okay. All right, Mr. Neal, your attorney is present, but before we get to the case with your attorney present, we do have some traffic misdemeanors that we're going to cover first. These are cases where you miss your original court date, so we're going to get you a new court date. And when you do attend these traffic misdemeanor dates, it's going to be with by means of Zoom. You're going to be using Zoom to dial in for your court date, which is the video teleconferencing technology that we're using today. You're going to receive instructions on how to dial in for your court date. Do you understand, sir?
Yeah.
Okay, as to the traffic misdemeanors, we're calling case number X314. 1072, people said Michigan versus Shantez Neal. So you're charged with misdemeanor. Count one, no operator's license or multiple licenses. You missed a court date. It's going to be a personal bond, no dollar amount listed. Ticket P865274. You are charged with counts 1, 2, and 3. Self-display of operator's license, driving on registered or untitled vehicle and improper plates. It's personal bond, no dollar amount listed. Ticket 453135, you are charged with drawable license suspended. You missed a court date. It's going to be a personal bond, no dollar amount listed. These tickets are misdemeanors. The penalty that you could receive is 93 days in jail and or a $500 fine. Do you understand the charges that were read and the penalty that you could receive on these tickets?
Yes, ma'am.
Okay, court will enter a not guilty plea on your behalf. There's a Zoom pretrial date, May 14, 2021 at 8:30 a.m. to Thursday District Court in front of Judge Ford. With any criminal matters, sir, you have the right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You also have the right to an attorney. If you cannot afford one on your own, the court will appoint one for you at public expense. Do you understand your rights?
Yes.
Okay, and at this time, the warrants are set aside and that bond is continued. Next is case number 210-57151, people say Michigan versus Shantez Neal. Counsel, on behalf of the defense, your appearance for the record, and we do have an attorney who's going to be checked. Oh, wait, disregard. I'm sorry, go ahead. I'm sorry, counsel, your appearance for the record.
No worries, Robert. Right around P3665 on behalf of Mr. Shantez Neal. Waive formal readings, can you, Mr. Neal has been advised of this constitutional.
Thank you. Court waives the formal reading, enter not guilty plea on your client's behalf. There's going to be, stand by. Okay, counsel, the court's going to enter not guilty plea on your client's behalf. There's going to be a Zoom probable cause conference date set for April 20, 2021 at 8:30 with the 36th District Court, followed by a Zoom clear examination date, April 27, 2021 at 9 o'clock at the 36th District Court. And it will be in front of Judge Jones and Esteban.
As the bond, Your Honor, I'd like the court to be aware that Mr. Neal indicates he's a 28-year-old lifetime resident here in the city of Detroit, and that he's had absolutely no contact with the criminal justice system in his whole life. He also indicates that for the last 3 years, he's been gainfully employed at Hayes Auto and Tire Shop, that he's a high school graduate in the community, and that he's not on any probation or parole. Now, most importantly, in this matter, I want the court to see that Mr. Neal will not be residing with the complaining witness. Our office practically advised him that there's going to be a no contact order, in which he maintains that he's confident that he's able to follow. He's going to be staying at a completely different address. He'll be staying with his mother, Your Honor. He has mother support, sister support. He has 6 children here in the community. I would ask the court to consider a personal bond. If the court is not willing to set a personal bond in this matter, I'd ask the bond not to exceed $300. Although he is gainfully employed, a lot of his money goes towards raising his kids and paying his bills. I believe that anything more than $300, Mr. Neal would not be able to post. So I'd ask the court for a reasonable bond, but not personal, and that bond not exceed $300, Your Honor.
Thank you. Did you see his bond? Are there any holds?
Yes, Your Honor, he has holds.
Thank you. And also, did you see, just out of curiosity, is there any indication of where or what they are for?
Says 37th District and 39th District traffic.
Thank you. Counsel, court takes into account representations, most importantly, your client's significant ties to the community, including family residential, as well as gainful employment in the community. And the court also takes into account and appreciates your proactively addressing what is going to be no contact order while this case is pending. The court, again, is taking into account the pandemic facing the nation and has been mindful of cases, including cases with allegations of an assaultive nature, and also on top of that, within the context of a domestic dynamic. This particular case, the court is going to distinguish for purposes of bond in that its concern is that a review of the file indicates, again, the allegations are that your client, what part of what drew the officer's attention to making contact with your client is that at the time that the officers were called, that your client, the report indicates that allegedly your client essentially made use of a firearm. Again, they're allegations only, but on top of that, that there were underage children involved in this incident peripherally, but more importantly, in that at the time that the officers observed your client, that at the time he was asleep. However, that the officers observed allegedly a firearm in his lap. He was asleep. However, what preceded that was that your client was not allowing anyone to leave the home, including the children, and that when the officers came upon him, the children were seated next to him, presumably unable or directed to not move, or for whatever reason were not moving, and your client was in the presence of these children with a firearm, and that is the court's concern. And again, laying the basis under the, as it relates to ensuring safety of the community, including that the complaining witness, including underage complainants, and because that poses a risk to the community and others in that residence. For those reasons, this court is going to set bond amount of $3,000, 10%. Also, your client is going to be subject to Wayne County Sheriff's GPS tether. So at your request, the court is setting the bond as you've indicated, but the court has articulated its concerns for why it's also going to impose the tether so that your client, to ensure that your client is not making contact. Otherwise, in the absence of a bond per your request, the court would have gone significantly higher. So to ensure safety to the community, the court is going to set, again, $3,000 personal bond. Let's write that, 10%. And Wayne County Sheriff's GPS tether. And no contact with the complaining witness, Adriana Williams. No contact means no written verbal communication with this individual, no messages to her through third parties, no contact or those extends to her place of residence and place of employment. And further, because the court has articulated its concerns with regard to the underage, although they're not listed as complainants in the case, no contact with these underage individuals who were a part of the alleged basis for the charges. That also includes no contact with the parents and or legal guardians of these children involved in this alleged incident, no contact with their schools or agencies that provide services to the children. Anything further?
Nothing further, we appreciate it.
Yes, sir. You're all set, sir. You can step away from the camera. Mr. Sanford, if you need me to sign a fresh MIT, if you need me to sign a fresh MIT on that one, let me know and I just throw it up there and I'll do it. So
You got notice that this person right here is timing out.
Okay. Okay. Got it. DDC?
Yes, Your Honor.
Let me ask you this. The court just received notice that Sylvia Nevins on the women's side is timing out. Is it at all, do you have staff over there where we can maybe switch gears, go over there? We do have an interview, so is it possible we can switch gears, get that one off our plate, and then we can come back?
Yes, Your Honor.
Okay, thank you, ma'am. We'll see you back shortly. If you can just let them know, we'll be joining them on the women's side shortly. We'll be with you in a moment, sir.
Yes, ma'am, thank you.
Oh, when you
Yes,
come
sir.
down, tell us do that Nevis lady, because she's timing out.
Thank you, Mr. Sam. Hi, ma'am, your name?
Sylvia Nevins.
Okay, Ms. Nevins, we have some cases here for you. Your attorney is present. But what we're going to do is first arraign you on a traffic misdemeanor ticket. You missed a court date. So we're going to get you a new court date. And when you do attend for the traffic misdemeanor, you're going to receive instructions by how to dial in for your court date using Zoom, which is the video teleconferencing technology that we're using today. You're going to receive instructions on how to dial in for your next court date on the traffic matter. Do you understand?
Yes.
Okay, and also when you do attend that court date, you're going to need to keep coming back for all of your dates until your judge tells you that you're done with the case, okay?
Okay.
Okay, calling X ticket 3472899, People State Michigan versus Sylvia Marie Nevins. Ms. Nevins, you're charged with misdemeanor count 1, no operator's license or multiple licenses. You missed a court date. The ticket is a misdemeanor. The penalty that you could receive is 93 days in jail and or a $500 fine. Do you understand the charge and penalty on the ticket?
Yes.
Okay, court will enter a not guilty plea on your behalf. There's a Zoom pretrial date, May 14, 2021 at 8:30 a.m. to Thursday District Court in front of Judge Ford. With any criminal matter, you have the right to remain silent. Anything that you say or lay on writing can and will be used against you in a court of law. You also have the right to an attorney. If you cannot afford one on your own, the court will appoint one for you at public expense. Do you understand your rights?
Yes.
Okay, at this time, the warrant is set aside and the bond is continued. And we do have your attorney present for your other case. We're going to do that one now. Calling case number 210-57143, People say Michigan versus Sylvia Nevins. Counsel?
Brian Morales, 3665, on behalf of Ms. Sylvia Nevins, we agree to stand here. This time is the advised for constitutional rights.
Full with formal reading, enter a not guilty plea on your client's behalf. There's going to be a Zoom. Stand by. There's going to be a Zoom probable cause conference date, April 26, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date, May 3, 2021 at 9 o'clock at the 36th District Court in front of Judge McConico and as to bond.
As a bond, Ms. Nevins is 28 years old, a lifetime resident. She indicates that she has no priors whatsoever. Unfortunately, Your Honor, she does suffer from cancer and other illnesses. That's why she was in the hospital with and has been involved. She's dealing with her disabled son as well. She's receiving government assistance. Our office is very proactive with her. We believe she's going to follow all orders of this court. We're asking the court for personal bond as we do appear to be on self-allocation.
Thank you. And did you see his bond when he holds?
Stand by, Your Honor.
I'm sorry, DDC, were there any holds?
No holds, Your Honor.
Thank you, sir. All right, counsel court takes into account representations, including your client's significant ties to the community and also her pre-existing condition. The court certainly wants to allow her to avail herself of the care that she is going to need. Also, court takes into account the pandemic facing the nation and that this is a non-assaultive case. Given those elements, court will set bond amount of $2,000 personal bond and no firearms while this case is pending. Is there anything further?
Oh, nothing further, Your Honor.
That's fine. You're all set, ma'am. You can step away from the camera. DDC, thank you very much. We're going back to the men's side.
Okay, Your Honor.
Okay. Counsel Scott, I believe. I don't think we have a file yet for Lawler. So just stand by. Again, we're still getting files coming in, but thank you for checking back in. We don't have your person just yet. All right. We're going back to the men's side.
Thank you, Your Honor.
Yes, ma'am. Okay. Hi, County. Perfect timing. We actually have two files for you. Who do we have on camera?
Your Honor, this is Mr. Burnett.
Okay, thank you. And counsel, we're ready on that case. Is that correct?
Ready, Your Honor.
Thank you. Calling case number 190-59944, People say Michigan versus Melvin D. Burnett. Counsel.
Brian Morales, 3665, on behalf of Mr. Melvin Burnett, we agree and mute Mr. Burnett from the advisory conference.
Go with formal reading, enter not guilty plea on your client's behalf. Counsel, before we get to dates, let the record reflect that this is a felony matter, and a review of the file shows that on October 4, 2019, your client failed to appear for an exam, at which time a capias was issued and bond saying amount of $10,000 cash by the judge of record at that time. And again, as it is the case with felony matters in the event of a capias, this court does not have automatic authority or discretion to make any changes to the bond. So has your office had an opportunity to review the bond? I mean, rather address it with the judge of record?
Your Honor, the judge of record has asked us not to reach out to that judge anymore on these matters, so we were not able to make contact.
Okay, so it is the case that at this time there's not going to be any change on the existing bond. Is that correct?
That is correct, Your Honor.
Okay, and let the record reflect that at this time it is Judge Archer. Is that correct?
That's correct.
And that's the courtroom that said essentially they're not going to make any changes on a case. Is that
I
correct?
believe so. That may be specific to this matter, but
That's- No, that's fine, but thank you for the clarification, just so that we've made a clear record and the court has a clearer understanding. Here's what the court is going to do. Let the record reflect, court will waive the formal reading, enter a not guilty plea on your client's behalf. There's going to be a Zoom probable cause conference date set for April 20th, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date, April 27th, 2020 at 9 o'clock at the 36th District Court in front of Judge Archer and as to bond.
Your Honor, Mr. Burnett is a 31-year-old lifetime resident here in the city of Detroit. Indicates to our office that he doesn't have a stable residence here in the community with his mother. These do appear to be non-assaultive allegations. Notwithstanding my knowledge of the court's policy and authority, I would ask the court to consider a reasonable bond, personal bond.
So noted. Thank you. County, if you're there, there's the bond. Are there any holds? Okay, they probably stepped away. All right, thank you, counsel. Given your representations, and again, the court again appreciates you giving information that helps this court understand how to proceed on the case. Given at this time that this court does not have the discretion to make any changes as to this particular case, court will continue the bond, set aside the warrant, continue the bond at $10,000 cash surety. Is there anything further?
Nothing further.
Okay, you're all set. Thank you, counsel. We are concluded as to Mr. Burnett.
Okay, Your Honor, I'll send the next one in. Okay, go on.
Yes, sir.
Yep, give me 1 minute.
Okay. Hi, your name, sir?
Eddie Raines.
Thank you. Calling case number 1905934, People State of Michigan versus Eddie Range. Counsel.
Ryan Marab, PA 3665, on behalf of Mr. Eddie Range, waive reading stand mute. Mr. Range has been filed with constitutional rights.
Full waive the formal reading and turn not guilty plea on your client's behalf as a Zoom probable cause conference date September 18, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date to be determined. And it will be, looks like it's a felony non-support matter in front of Judge Giles and Esteban.
Mr. Bond, Your Honor, Mr. Range is 47 years old, a lifetime resident here in the city of Detroit. Doesn't indicate to our office that he does not have any prior criminal history. Was gainfully employed, Your Honor, but that was extremely affected by COVID as he was working in different homes. Indicates that he cannot post a monetary bond. I understand the court is statutorily required to set bond at 25% of the arrearages. I'd ask the court to do so in a personal bond in this matter. He does understand to follow all orders of this court as well, Your Honor.
Okay, so noted. Thank you. Counsel Court takes into account your representations, including the pandemic faced in the nation, as well as this being a non-assaultive matter, and further that your client clearly has significant ties to the community, including what was up until the time of the pandemic, gainful employment in the community. Further, this court is required by law to set bond in the amount of 25% of the dollar amount the state alleges that he owes. In this case, just over $2,000. Given your representations and the pandemic facing the nation, and this is non-assaultive, court does find there's a basis to set aside to depart from the statutory requirement set by the amount of $2,000 personal bond. Is there anything further?
Nothing further, Your Honor.
Okay, you're all set, sir. Thank you. We are concluded. Okay. Okay, we're going back to DDC midside. Okay. Hi, DDC. We are back. We ended up taking a couple of cases out of the county, so we are back. We should be able to go straight down your list. Also, we do have updates on files. Let me know when you're ready on the update.
I'm ready, Your Honor.
Okay, we now have files for Chayoki Funches. We have Deshaun Smith. We have Angelo Lawler. We know we had parties on Lawler. We're ready on Lawler. We also have file ready on Clinton Howard. And we have Anthony Rojas, R-O-J-A-S, Rojas. And your name, sir, again, for the your name on camera, sir, with the Panthers sweatshirt, your name?
It was Anthony B. Jackson.
Okay, we've got a file for that. Thank you. Calling case number 2105706, People State of Michigan versus Anthony Jackson, counsel. Yes, sir. Connor and Lawler. Connor, Lawler, we have Lawler. Okay. DDC, if you would please, can we pass on, you said that was Anthony Jackson? Jackson? Okay, can we pass on Anthony Jackson, please? MIDC just needs a few more minutes before we can proceed on him. Let the record reflect, we do have a file for Lawler, plus we have a prosecutor on Lawler. But I think otherwise we have matches for everything else. Is that correct, counsel? We have matches for everything else, DDC.
I'm standing right here.
Mm-hmm. No, don't
Hi,
take
your
that
name,
off.
sir?
Angelo Lawler.
Okay, Mr. Lawler, okay, yeah, keep that over your nose and mouth. That's for your safety while you're there, sir. I believe we also have a prosecutor here on Lawler. Attorney, Prosecutor Scott. We have Prosecutor Scott in the room. Oh, where'd she go?
Your Honor, I just texted her.
Say again?
I just texted her that her case is up. She should be here momentarily.
Thank you very much. Okay, stand by, everyone. We have a prosecutor who's going to be checking in on the case, so stand by. As soon as she's on screen, we'll proceed.
How you doing today, Your Honor?
Hi, who was that?
That was me, Mr. Lawler.
Oh, okay. Hi, Mr. Lawler. Doing well. Thank you for asking, sir. Yeah, please keep that over your nose and mouth. It's for your safety, sir. Thank you.
Okay.
Your Honor, did the attorney check in on Mr. Anthony Jackson?
Not to the court's knowledge. Well, we have an attorney for Connor, but I don't believe that anyone's checked in on Jackson. Not that the court is aware of.
Or Rojas?
No, sir.
Yeah, I know you can. I'll just print it.
Gotcha.
Okay, I think Attorney Scott will be joining us shortly. Hi, Attorney Scott. Thank you very much for your patience. We do have Mr. Lawler on camera, on screen. I think we have everyone present, so we're going to call the case.
Thank you, Your Honor.
Yes, ma'am. Calling case. Calling case number 190-46508, People State Michigan versus Angela Lawler, counsel.
Ryan Moran, PA 3665, on behalf of Mr. Angelo Lawler, who will waive readings and mute. Mr. Lawler is going to advise this constitutional right.
Full with the formal reading and turn not guilty plea on your client's behalf. Counsel, before we get to setting dates, we do have a prosecutor here. You've made your appearance. Let the record reflect a review of the files that on January 16, 2020, Mr. Lawler failed to appear for a final pre-trial, at which time Judge King, presiding over the case, issued capias and set binding on a $1,000 cash surety, which leads us to today. And Madam Prosecutor, if you would, your name and P number for the record.
Natia Scott, P number 78816, on behalf of the people.
Okay, and counsel, because there was a capias issued, and this court recognizes that because it is a misdemeanor matter, Judge Bryan has given this court authorization or discretion to make changes to a capias bond. So you are welcome to address the issue of bond, including, if you know, why he failed to appear for his final pretrial, and then Madam Prosecutor will have an opportunity to address bond as well.
Absolutely. Sir, Mr. Lawler.
Mr. Lawler, stand by, sir. The attorney is here. Allow him to speak, sir.
I'm listening.
Go ahead, counsel.
Okay. And Your Honor, I'd like the court to know, Mr. Lawler is a 37-year-old lifetime resident here in the state of Michigan. He advised our office that he does have a child who's very active in his family as well. Mr. Lawler had a great job. He was in the crisis since this pandemic. Unfortunately, he was laid off. He's currently receiving government assistance and unable to post a monetary bond, Your Honor. He does indicate to our office that he's not on any probation or parole, and that he does take medication, which he has not received since being incarcerated. Your Honor, he wants the court to know that he believes that he may have been incarcerated while that on December 2019, and that's why that court date was missed. We've not had the opportunity to verify that yet, Your Honor, but I would ask the court, considering his ties to the community, his inability to post bond, the misdemeanor nature of these allegations, Your Honor, I'm asking for which we believe Mr. Lawler has no problem following, and we would ask the court for a personal bond in this particular matter. And I'd ask the court to amend the capias bond as he did indicate he was incarcerated. Our office has gone over the Zoom protocols with Mr. Lawler, and we're confident that he's going to follow all orders.
That's not me. I didn't do that. I didn't get in trouble in 2019. That's what I'm trying to say. Excuse me.
Okay, Mr. Lawler. Mr. Lawler.
Yes, ma'am. Yes, ma'am.
Sir, the court is going to request that you remain quiet. Your attorney is doing a fine job. He's making representations on your behalf, sir. Allow the attorney to represent you and do his job.
All right, can I just ask, can I just say one thing to the
Sir, Mr. Lawler, again.
Yes, I'm listening.
Okay, Mr. Lawler, one, keep that mask over your nose and mouth. We can hear you. Keep that over your nose and mouth. That is for your safety while you're there, sir. Also, let the record reflect, this court is going to remind you briefly that you do have the right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. This court is confident that the attorney has advised you of that. So please exercise that right. Let your attorney make his representation. Stand by. Madam Prosecutor, you've made your appearance in your P number and as the bond, please.
Your Honor, this is not the case that I am appearing under. I just filed charges for the defendant for capital crimes, actually yesterday. So you should have a file where the defendant is charged with assault with intent to murder, assault with intent to do great bodily harm, less than murder, and felony firearm counts for each of those charges, a felon in possession, and he is a habitual force. So that's where I'm appearing on because I just signed that warrant yesterday.
Okay, and thank you, Madam Prosecutor. The court appreciates you addressing the court as it relates to an unrelated matter, but with regard to Mr. Lawler, because one of the factors as it relates to the instant case are twofold, and counsel, the court will give you an opportunity to review that, to address it. But to begin, as it relates to this particular case, one is that the court does note that as it relates to this case, this particular matter, Mr. Lawler failed to appear for a final pretrial, which means that at some point Mr. Lawler was present in court and was aware that, and at final pretrial indicating that Mr. Lawler expressed his intent to proceed on this matter to trial, meaning that the court, as well as all agencies interested in the case, were preparing to go to trial, and at which time, sir?
Miss Your Honor, that's not me. I didn't get in no trouble in 2019. That's not me. Dang, I'm trying to explain to y'all. Miss Your Honor, yes, I hear you, miss. I hear you. Y'all treating me like a person. This is unjust, man. Y'all not giving me a chance to represent myself. I'm listening. I'm listening.
Mr. Lawler. Okay, stand by, sir.
I'm listening.
Everything that you're speaking on, sir, are things that are going to get addressed at the next court date. So today is only for the purpose of getting this case back on track.
Okay.
Thank you, sir. Given what has been presented, including representations by the prosecutor, but as it relates to the instant case before the court at this time, is that, again, any elements with regard to the basis of the charges on the instant case are elements that need to be addressed in front of a judge with the parties present as they prepare to go to trial. So the purpose of today's proceeding is to get this case back on track and to ensure that Mr. Lawler does appear in court for each stage of the proceedings going forward. Also, the court is taking into account appearance by Madam Prosecutor as it relates to Mr. Lawler in custody, or rather that there are charges pending with regard to other matters to ensure, again, the integrity of all matters that may be pending for the court, regardless of the stage that it is at. Stand by. With that being said, counsel, anything that you wish to address at this time?
I do, Your Honor. First, I just want to point out that bond is subject to review on a case-by-case basis. I'd ask the people to raise their arguments when they're here, when that warrant that was signed is actually signed by a neutral detached magistrate. At this point, Your Honor, we're dealing with a simple assault and battery case from 2019. My notes may reflect something different than what Mr. Lawler is trying to say to the court. As soon as this hearing is done, Your Honor, we're going to have to speak to Mr. Lawler on camera 2 to verify and update this court with any information. But I do have a note, Your Honor, that indicates that he may have been incarcerated. That's why his court date was missed. I know he's indicating that that may not be the case. We're going to clear that up as soon as we get off the record, Your Honor, with him on camera 2. That will provide this court with any additional updates. But with respect to this bond, I would ask the court to not deviate from what it was typically said in a misdemeanor matter that's older and of this nature. Again, it does not appear that these are allegations that took place in a domestic dynamic. With all that said, Your Honor, I'm asking for a reasonable bond, actually a personal bond in this matter. He's laid off, he's receiving government assistance. He does suffer from some mental health issues as well, Your Honor. And I want to make sure he's able to get the proper treatment that he needs. I'm not confident that he gets that treatment in the Wayne County Jail. Again, he has a child, he's very active in his life. People in Mr. Lawler's community vouch for him, Your Honor, and consider him to stand up there. And I understand the court sees something different, but I think Mr. Lawler is frustrated. He's incarcerated right now. This is an older matter that he indicates he's not aware of. He does not believe that this should be him. So I totally understand his frustration. And I'm just asking the court to hear all this out. Again, we're hearing this misdemeanor charge, Your Honor. I'm asking this court for that no contact order. He doesn't live with the complainant. We ask for personal bond. He knows to return to court. And if that warrant is signed by a magistrate and those charges are pending, and that should be taken up properly when the defense counsel has all that required information. At this point, it's a blind side. So we're asking for personal bond in this matter, Your Honor.
Okay, thank you. And the court appreciates each side. I'm sorry, ma'am, go ahead.
Your Honor, I would respectfully ask that you deny defendant's request. In light of what the prosecutor just put on the record with the new pending charges, defendant is a danger to society. I ask that you reinstate.
I'm not a danger, Your Honor. Your Honor, I'm not a danger. Your Honor.
Hey, Mr. Lawler. Hey, Mr. Lawler.
No, Miss, Your Honor, Your Honor, can I please say something, please? Can I please say something?
Mr. Lawler,
I'm listening.
Mr. Lawler, this is the court speaking. Okay, again, what? Mr. Lawler, again, this court has cautioned you with regard to your advice of rights, which includes the right to remain silent.
All right.
Understand,
All right. Man, this lady here trying to fuck my life up. This lady trying to mess my life up. She trying to, I'm not a danger. Man, I'm listening, man. I'm listening, Your Honor. Listen.
Okay, Mr.
I'm listening,
Lawler.
Your Honor. I'm listening. I'm listening. What else?
Mr.
Why do y'all
Lawler.
want me in prison around here? Why am I a
Mr.
victim
Lawler.
to your judicial system? Y'all hurting my life. Fuck, leave me alone.
Mr. Lawler.
Yes, ma'am. Yes.
Thank you, sir.
Okay. Man, y'all trying to throw my life away around here, man. I ain't did shit to nobody.
Mr. Lawler.
Yes,
Mr.
I'm listening.
Lawler.
I'm listening.
Thank you. Here's what we're going to do. As it relates to the instant case, counsel, the court is going to mark on the minimus. The dates remain the same. Let the record reflect. The pretrial date is going to be April 26, 2021 at 8:30 a.m. the 36th District Court, and it will be in front of Judge Bryant. Further, counsel, per your representations, court has marked the file medical for the reasons stated on the record, and the court does appreciate you highlighting that for the court's consideration. The court is also taking into account everything that you've indicated on the record under the court rules. Bond is subject to review at any time, but the court is also taking into account, again, outside of the people's representations, the court is simply looking at the elements of this case. As the court indicated earlier, in addition to the pandemic facing the nation, the court is mindful of that, and the court is marking the file accordingly. Further, the court is taking into account that the gentleman did miss a final pretrial date, indicating that there was some indication on behalf of the client with regard to proceeding to trial. So noted, sir. So here's what we're going to do. The only thing that we can do is, the purpose is to get this case back on track, which is exactly what we're going to do, and we're going to do it in as expeditiously as possible. Therefore, the date is April 26, 2021. The file is marked medical. The bond remains the same at $1,000 cash surety and no contact with the complaining witness Landon Neal. No contact means no written or verbal communication.
Man, that's not me. I don't know no Landon Neal.
No contact with since the place of residence and place of employment. At this time, we are concluded. Thank you. We are concluded.
Your Honor. So Your Honor. Hold on.
If you can make the gentleman available. We're going to do that right now, sir. Sir, we're going to do that right now so you can speak with the attorney. DDC, can you make the gentleman available on camera too?
You want to put me in front of the camera too, Your Honor?
Yes, sir. So the attorney can speak with them.
I ain't even do shit.
Sir.
Your Honor, man, fuck you, bitch. Fuck you, bitch. You a corrupt bitch. You a corrupt bitch. Fuck you, bitch. You a corrupt bitch. Fuck you, bitch. You a corrupt bitch. I kick your ass, corrupt bitch. You corrupt bitch. Fuck you, corrupt bitch.
I'd ask the court to accept my apology on behalf of my client.
It's fine. And counsel, thank you. You've addressed everything adequately, and the court appreciates you advocating so vigorously on behalf of your client. I think that we've been able to make precautions further. The court has indicated that you'll have an opportunity to speak with the gentleman. Okay? Thank you, sir. GDC, when you're ready, let us know.
Give me a second. He threw he cracked the screen. I can't even see you. He threw you. Look what he did.
I see.
Now you gotta get a hold of me. Yes, Your Honor.
Okay, no, that's fine. We appreciate you. Listen, if you need to take a moment, that's fine. We appreciate anything that you need to do. Listen, if you can, we just want to give you a quick update. Let us know if you're ready. I know you had to take care of a couple of immediate matters, but let us know. We do have some updates for you.
Yes, I'm ready, Your Honor.
Yes, ma'am. Yes, ma'am. Just let us know.
I'm ready.
Okay. We have an update for Dayton Taylor, a file on Dayton Taylor. On the women's side, we have Michelle Allen. Michelle Allen. We have Lawrence Wagner. Lawrence Wagner. We have Connor. Shantez Connor.
No, I'm just saying.
And I believe there's a...
So what, I gotta stay in this motherfucker to the next court date? I'm leaving.
He can have charge.
So where I'm going? Where I gotta go? Man, no, man, this is bullshit.
That's why I got doing the most.
Okay, Council, we'll just wait. I mean, they might need a moment to just get back up to speed.
Here, we always be in here. He took his mask off.
Sorry, come around. Sidebar.
We was all in the hallway.
Now y'all gonna have a whole bunch of shit that they gonna change. Y'all gonna do a whole bunch of shit.
That motherfucker
They gonna have to be
change.
puffed in here.
They ought to be all that craziness.
Yeah.
Ooh, he was getting too riled.
And just let us know when you're ready. We can
Look what he did.
It still affects the date, so just get seconds.
For you? How did he do that?
I wish that down here because he's doing all this.
Okay.
Number two out there.
Lady, excuse me, Officer Jones. Officer
Your
Jones,
Yes.
be advised, and I realize you may have a supervisor there with you, be advised and let the record reflect that we're still recording and we are streaming live to YouTube. So if it is the case that we are experiencing the potential basis for another case, you may want to speak off screen or just wait until we stop recording. Or if you need a moment to stop recording, we can do that. So I can stop recording. Stand by.
Yeah.
We're going to stop recording.
Yeah, because we can't use
Because we're done with this room.
Okay, no, thank you. So here's what we're going to do. I've stopped recording. Give us one moment. We're going to change cameras to men's camera 2. Is that correct? We're going to men's camera 2. Is that correct?
Ma'am.
Yes, Your Honor.
So we threw this.
Okay, we paused the record. We paused the recording. I'm going to remove this camera. We're going to go to camera 2 shortly. We'll see you there.
Thank you, ma'am.
Okay, we're about to go back on the record. Stand by.
They're on camera 2. I'll make sure that we get off on camera 2.
Yeah, just let them know what happened, that we need to finish on camera 2, and we'll make adjustments accordingly. We're all set? Thank you, ma'am. Okay, we are recording again. We're on camera 2, and we're still streaming live. Let us know when you're ready. Okay. Oh, you know what? Disregard, hang on. Hang on. I dialed into the wrong room. Let me fix it. Hi, DDC. We are back. We are recording, and we are live on YouTube. Just let us know if there are any files that we need to update you on, because I think previously we had given Officer Jones the update on files, and if she is occupied and we have someone else with us, we can go over files when you're ready.
Copy that, Magistrate Sherman. We're in the process of moving our operation over here to the second room, so give us a second. We're right with you, ma'am.
That's fine, sir. We'll just wait at your discretion.
Copy that.
Court sends a brief recess. We're still recording. Hey, you guys, hang on. I might have to disconnect and go back in. It seems Zoom might have kicked me out, so let me see what I got to do. DDC, stand by. On our end, it looks like Zoom may have kicked out the court, so the court might have to shut down and reboot, and we'll join you again shortly. Do you copy? Hi, DDC, is anybody there at camera 2?
Yeah, I'm here now, Your Honor.
Hi, ma'am. Listen, this is unrelated to you guys. The court stepped away when we came back. It appears that Zoom may have kicked us out. So just stand by. We'll dial back in. I might have to shut down and reboot. but we'll be back shortly on men's camera 2, okay?
Okay, I know they're trying to put up another camera back in camera 1 so y'all can continue to do what you need to do. So they took the one off and they putting another one up.
Thank you very much. Actually, thanks for that update. So we're getting an error on Zoom. So we're just going to come back on camera 2 and we'll get an update when you're ready. I mean, if you have an update for us by then, just let us know. But thank you very much for the update.
Copy.
Okay. I'm going to go back in. I'm just going to restart it. So I don't know. It may or may not make a difference. We'll find out. You see the charges? Oh, well, yeah, come in.
Magistrate Sherman?
Number 1.
Yes, sir.
We replaced the screen in video 1. Can you call us back on 1? Let's see if it works, man, please.
Okay, yes, sir. Let me get the recording equipment going, and then I'll close out here, and I'll join you shortly.
Thank you.
Thanks for the update.
So, go ahead.
Ma'am, I'm going to go ahead and log you off here, and I'm going to call from this TV to that TV, make sure it's working, okay?
Thank you very much. Yeah, because I'm having trouble getting in, so that might be part of it. So yeah, if you disconnect from there, let me just reboot, and I'll join you on one again.
All right, thanks.
Thank you. Awesome. Okay. Grandpa, was it no dollar amount bond listed?
Yeah.
Okay, I think we're in. We're still streaming live. And, okay. Still streaming live. I think We're back. I just have to see if I can get into DDC. Hey, we're in. Hi, DDC, we're back. Can you see us and hear us?
Yes, Your Honor.
Wonderful. Okay, we're back up and running. Thank you so much, you guys. We're back. We're recording. We're live on YouTube, so we can pick up where you want to leave off. Earlier, just as everything, you guys were trying to get situated with the new equipment, we did receive some new files, so if you want, we can start from the top of that, or just let us know where we're picking up.
Can you give me all the files that you have, Your Honor?
Well, I can go over everything that we do have just to kind of get up to speed again. Let me know when you're ready.
We're ready, Your Honor.
Okay, in no particular order, we have Rojas, Anthony Rojas. We have, it's like Clinton Howard. We have Deshaun Smith. We have Chayoke Bunches. We have Jackson, Anthony Jackson. Brandon Childs. Shantez Connor. And by the way, we do have a prosecutor and a retained attorney on Connor. So actually, if Connor is available, we can get that toward the top and get it done. Dayton Taylor and Lawrence Wagner. That's everything that we have for files. And on the women's side, Michelle Allen.
Copy that, Your Honor.
Thank you. Okay.
That sheet on the counters, I don't have nothing on him. Leave him not.
Hey, how you doing? My name is Shantez Connor.
Okay, stand by. Sir, we had some technical things going on, so we're going to make sure we've got all of our parties in the room, so stand by 1 second. Do we have attorneys for Connor? We have Connor on screen. Let us know when you're ready. We see
Ready, Your Honor.
Attorney Talinda and Prosecutor Franson. I think we've got everybody ready to go. Okay, we're on the record. Calling case number 210-57153, People State of Michigan versus Shantez Connor Jr. On behalf of Mr. Connor, your appearance for the record and your P number, please.
On behalf of Mr. Connor, Paul Talenda, P72495.
Okay, thank you. And on behalf of the people, your appearance, please.
Good afternoon, Your Honor. Matthew Franson on behalf of the people, P84002.
Okay, thank you. And on counsel, on behalf of Mr. Connor, are you waiving the formal reading and sending your client mute?
Yes, Your Honor. Thank you.
Okay, court waive the formal reading, enter a not guilty plea on your client's behalf. There's a Zoom probable cause conference date April 20th, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date April 27, 2021 at 9 o'clock at the 36th District Court by Zoom in front of Judge Giles and counsel on behalf of Mr. Connor as the bond, sir.
Your Honor, Mr. Connor has no prior offenses. He's got no criminal record. He's 19 years old. He's got family support. I was contacted by his family on the day of the arrest. I've been retained on this matter. He does have, again, family support. They're residents of the city of Roseville. So they are within proximity to the city, Your Honor. Has no convictions, has family support. I'm retained in this matter. I asked for a personal bond on this matter and anticipating an associated no contact order with the complainants or the victims of this matter.
Okay, thank you. And on behalf of the people.
Your Honor, these are extremely serious charges. The defendant is accused of being in a stolen 2021 Dodge Charger with two other individuals. The three individuals chased and shot numerous times at a vehicle with five other individuals in them. It's my understanding that they're totally unrelated and there's no connection between the defendant and the victims. In the vehicle was a 31-year-old young lady, three 16-year-olds, and a 9-year-old. These people were going to a cousin's birthday party. when they were chased and shot at approximately 8 to 10 times by these individuals. The vehicle that defendant was in led police on a high-speed chase through the streets of Detroit, at which point the car crashed into a building. This defendant and the 3 other defendants, or 2 other individuals, ran from police. An officer saw a handgun in this defendant's hand, which was later found. That handgun was a .40 caliber handgun, and there was 8 .40 cals found at the scene. Given these offenses, the people asked for a high cash bond. That's about it. Thank you, Your Honor.
Okay, thank you. And counsel, on behalf of your client, is there anything else that you wish to address before the court addresses the issue of bond?
Yes, Your Honor. I can appreciate the nature of the allegations. However, that's all they are at this point. It's our allegations. Respecting that that Mr. Connor is innocent until proven guilty, Your Honor, I'd ask the court to establish a bond, perhaps with a reasonable cash bond, if the court's so inclined, in order to allow Mr. Connor to continue on with his completion of his GED, as well as to aid in his preparation of his defense with my office. We're going to ask for a cash bond if the court's so inclined, with a 10% provision, something that would be reasonable for the family to obtain.
Okay, thank you. And did you see if you have any information as to bond, or are there any holds?
It just says see second page, and the second page is not there, but normally that's where holds will be, Your Honor.
All right, thank you. All right, thank you, ma'am. All right, counsel's court appreciates the time that you've taken to address this court as it relates to the nature of the charge and the seriousness of the allegations and the positions of each party as it relates to the case. Court does take into account elements that each side has highlighted, including Mr. Connor's significant ties to the community, and further counsel on behalf of Mr. Connor, court does appreciate that you're going to want to have your client available to you to be able to aid in his defense. Court is also balancing it with the nature of the charges and the seriousness of the allegations, including the pandemic facing the nation, which is a newer element. But the court is also balancing it with the seriousness of these charges, which includes multiple counts of a highly assaultive nature, including multiple counts as it relates to an alleged use of a firearm. Court also takes into account that as it relates to the nature of these alleged events, that as it relates to the elements that the court considers as it relates to bond, court also takes into account the nature of the ensuring safety to the community. These include allegations of a very precarious nature, allegedly that there was a series of events where there were shots allegedly fired in public, on a public roadway, with multiple individuals directed at a vehicle with multiple occupied by multiple individuals, including individuals who are under the age of 18. Further, that it poses a danger to the community at large, in that, again, these allegedly happened on an open street in public where other members of the public were present. Given those elements, and also to ensure that Mr. Connor is present for all stages of these proceedings. At this time, court is setting bond amount of $500,000, cash surety, no 10%, no early administrative release. Also, let the record reflect that bond is subject to review at any time. Also, while this case is pending, Mr. Connor is to have absolutely no contact with complaining witnesses DeWanda Bell, Dion Griffin, Curtis Dodd Jr., Jalik Stevenson, and Mark Bell. No contact means no written or verbal communication with these individuals, no messages to them through third parties, no contact order also extends to their places of residence and places of employment, and no social media contacts directly or indirectly. Also, if the court has not addressed it, let the record reflect there was a Zoom probable cause conference date April 20th, 2021 at 8:30 at the 36th District Court, followed by preliminary examination date April 27, 2021 at 9 o'clock at the 36th District Court in front of Judge Giles. Also, as it relates to any of the complaining witnesses who are under the age of 18, the no contact order also extends to their parents and or legal guardians, and no contact with those underage complaining witnesses, any agencies or schools that provide services to those underage complainants. Counsel, on behalf of Mr. Connor, is there anything further?
Your Honor, would the court consider a 10% provision considering the amount of bond? I don't
Stand
think
by. On behalf, I'm sorry, go ahead. Go
I was
ahead.
gonna say, I don't, just for practical matters, I know that the 50,000 isn't practical. I certainly have my concerns whether or not the 50,000, if there were 10% provision, would also be practical. But I ask the court to take that into consideration.
So noted, thank you. And on behalf of the people, before the court addresses the motion, if you wish to address the motion.
Yeah, Your Honor, the people would oppose any 10% provision. I think, given the nature of the charges, 500 cash is, I think, is fair.
All right, and gentlemen, again, the court appreciates the arguments that are presented to this court, and the court again has articulated its concerns on the record, but not so much that, but essentially on its face, based on the criteria the court utilizes under Michigan court rules as to bond, that these are allegations of a highly assaultive nature, including 5 counts of a highly assaultive nature directed against multiple individuals. Further, court again reiterates its concern with regard to the overall safety of the community, and including the set of circumstances as it was allegedly in place at the time of this alleged offense. For that reason, at this time, court is going to deny the motion with regard to any changes or consideration for bond. But again, under the court rules, bond is subject to review at any time. So certainly either party is welcome to address this court's bond determination at any time. Counsel Talinda, is there anything further at this time?
That's all. Thank you, Your Honor.
Okay, thank you. Anything further on behalf of the people?
No, Your Honor, thank you very much.
Thank you, Mr.
Okay,
Franks.
thank you, everyone. We appreciate you. We appreciate your patience. And at this time, we are concluded. Thank you. DDC, thank you. We're concluded. As Mr. Connor.
Mr. Connor, I'll come see you very shortly.
DDC, at this time, I don't think we have any retained attorneys. You should be able to go down the list.
Sean Smith.
Hi, your name, sir?
Sean Smith.
Thank you, sir. Hi, counsel, everybody on Smith? Okay, we are on the record again, calling case number 190466464, people say Michigan versus Deshaun Nathaniel Smith. Counsel.
On behalf of defendant Mr. Smith, who waits for more reading, understands the constitutional rights and stands.
Court waits for more reading, enter a not guilty plea on your client's behalf. Counsel, before we get to dates, if you would please, or if your office is prepared to address the issue of bond, let the record reflect. Review of the file shows that on January 8, 2020, Mr. Smith failed to appear for a sentencing, at which time then presiding Judge King issued a capias and set bond amount of $1,000 cash surety at sentencing. Is your office prepared to address that capias?
Yes, Your Honor, it is a misdemeanor and it is front of Judge Bryant. The court does have authority to change that bond.
So noted. Is your office prepared to address why your client missed his sentencing date? Because that suggests that your client was present long enough to address all other proceedings and was fully aware that he needed to return to court, but he failed to do so. Further, let the record reflect that this was in January 2020, which was before the state stay-at-home order regarding the pandemic. So this is before that issue.
And Your Honor, according to Mr. Smith, and I know that this is not, he knows that this isn't an excuse, but things happen. So according to Mr. Smith, on that particular day, his ride that he had arranged had failed, but he did talk to the probation officer and he did his interview over the phone. So he's trying to make steps towards doing the right thing when he couldn't get down here, Your Honor. But Mr. Smith does understand that that is not an excuse, that there will be no excuses, that there are other ways to figure out how to get down here. But Your Honor, for the record, that's what happened at that time. Mr. Smith is 18 now. He was even younger back then. I don't believe he was even able to drive, Your Honor. He was 16. So again, Mr. Smith understands that's not an excuse. I understand that's not an excuse, Your Honor, but that is the truth. So I am respectfully asking the court to give Mr. Smith a chance. He is 18, he's 60 at the time, and he understands the seriousness and he understands what's going to happen if he does not appear in court, Your Honor. And he does have his mother's support. He lives with his mother. She's on top of this, Your Honor, so I'm respectfully asking for a personal one.
Thank you. DDC is bond any hold?
No holds, Your Honor.
Thank you. Counsel, court does take into account that earlier This case was previously in front of Judge King and is now in front of Judge Bryant, and Judge Bryant has given this court authorization to use its discretion as it relates to capias bonds that were set. Here's what the court is going to do, and the court does take into account your client does have significant ties to the community. It's a misdemeanor matter, although it is of an assaultive nature, and your client, for whatever reason, did miss his sentencing date. The court appreciates that per your representations, your client has represented to you that he's made efforts to make contact with this court. So the court will do the following. The court will utilize its discretion, set bond in the amount of $2,500 personal bond. Also, your client is going to be subject to Wayne County Sheriff's GPS tether. He needs to make it to court. That's the priority. Also, because this case of the nature of the case and because it remains open and pending, your client still have no contact with the complaining witness, Dylan Boyle. No contact means no written or verbal communication with this person, no messages to him through third parties, and then no contact order also extends to the place of residence and place of employment, and no social media contacts directly or indirectly if that is the court's determination. Is there anything further? Okay, you're all set, sir. You can step away from the camera. I'm sorry. Did you see the date is going to be the following? I'm sorry. Review date set for May 7, 2021 at 8:30 at the 36th District Court, and it will be in front of Judge Bryant. I'm sorry. Thank you, counsel. Is there anything further? Okay, you're all set, sir. You can step away from the camera.
It's new. Uh-huh.
Anyway, how are you doing?
I'm doing good. So how the warrant conflict?
I didn't look because we've been going full time, so we're still kind of busy, so I haven't got to.
Okay.
But yeah, touch base with Dawn. Yeah, or just touch base with Dawn or something like that. But otherwise, I don't think she's had a break this week. It's been slow. So maybe touch base with her.
I'll check.
If you don't mind. Thank you. I appreciate you.
Thank you, sir. Stand by. Stand by. Okay. Hi, your name, sir?
Anthony B. Jackson.
Okay, Mr. Jackson, we are ready for you. Calling case number 210-57068. Houston, Michigan versus Anthony Jackson. Counsel, your appearance, please.
Mr. Jackson has retained counsel in our office and made contact.
I am on Zoom, Your Honor.
Oh, thank you very, I'm sorry, ma'am. Thank you. We missed you. Stand by. Okay, counsel, tell you what, we're going to call the case number 210-57068. People say Michigan versus Anthony Jackson. Counsel, your appearance and P number for the record, please.
Chiquita Palmore Bryant, P number 63927. I am appearing via Zoom. It does say that I'm having connection issues, but I am able to see and hear everything and ask the court to allow me to proceed.
Okay, well, we can hear you. I'm not seeing you right now, but if you could give us the P number one more time.
63927.
927. Okay, gotcha. Thank you very much. Are you waiving the formal reading saying your client mute?
Yes, ma'am.
Thank you. Oh, wait, the formal reading enter not guilty plea on your client's behalf. There is going to be a Zoom probable cause conference date set for May 10, 2021 at 8:30 a.m. at the 36th District Court, followed by a Zoom preliminary examination date to be determined, and it will be in front of Judge King and as bond counsel.
As to bond, Your Honor, we believe Mr. Jackson is not a slight risk. He has significant ties to the community. He is a retired officer. We request a personal bond with no restrictions on his weapon as he currently uses it for his work assignments.
Okay, okay, so you indicated that your client is retired, is that correct?
That is correct.
Okay, and is that in his, you indicated that your client is retired, did I hear that correctly?
He is correct. He is retired from DPD.
Okay, stand by. Is it, and again, without touching on the basis of the case itself, stand by. So just to clarify, the basis of these allegations or these charges are based on when he was in his capacity as an officer, is that fair to say, without touching on anything related to the case?
Yes, ma'am.
Okay. Stand by. And before we get to dates, I mean, the court is inclined to maintain that date of May 10th. Stand by. Court's going to review the file as it relates to your motion regarding conditions of bond. All right, counsel, thank you very much. The court wanted an opportunity to review the file. Let the record reflect there's going to be a Zoom probable cause conference date May 10, 2021 at 8:30 a.m. to Thursday District Court, followed by a Zoom preliminary examination date to be determined at the Thursday District Court in front of Judge King. And counsel, I believe you've already, you were beginning to make your bond arguments. Was there anything else as to bond or conditions of bond?
And no other retention.
Okay, thank you. Counsel, here's what the court is going to do. The court takes into account your representations, including the context in which the basis of these charges, charges were set. And again, these are allegations only. Here's what the court is going to do. Court will set bond in the amount of $7,500 personal bond. While the case is pending, no contact with the complaining witness, Corey Cade. No contact means no written or verbal communication with this person, no messages to him through third parties, no contact or those extends to place of residence and place of employment, and no social media contacts directly or indirectly. And again, the court at this time is not going to impose any restrictions or any other conditions at this time. But of course, under the Michigan Court rules, bond is subject to review at any time. So just counsel, your office may want to just be prepared to address any changes in bond or conditions of bond. Is there anything further?
Thank you, Your Honor. We appreciate it. Nothing further.
Okay, thank you. Thank you. DDC, we're all set. So you can step away from the camera. Sorry.
She's a counsel, right?
Yeah, she's an attorney. I'm sorry, counsel, could we get your name again, please? We have your P number. Can you get your name again?
I'll spell it for you. It's on the banner. CHIAETA. And the last name is P like purple, ALMORE-BRYANT.
Okay, PALMORE hyphen, what is it again?
Bryant, BRYANT.
Okay, thank you so much. Appreciate you. Anything, stand by. Okay, thank you, counsel, we're all set. Thank you. Hi, did you see? Okay, I'm sorry, sir, in front of the camera, who did your name, sir?
Clinton Howard.
Okay, we're ready on Howard calling. Stand by, Howard. Okay, calling. Stand by. Okay.
Oh.
Okay, calling case number 210-56040, People State of Michigan versus defendant number 1, Clinton Howard. Counsel, your appearance, please.
On behalf of Mr. Howard, who is formal reading and understands his constitutional rights and standards.
Go with the formal reading, enter not guilty plea on your client's behalf. There's going to be a Zoom probable cause conference date, May 10, 2021 at 8:30 a.m. to Thursday District Court, followed by a Zoom preliminary examination date to be determined at the Thursday District Court in front of Judge Archer. And as to bond.
Mr. Howard is 24 years old. There's no prior adult criminal convictions, to my knowledge, is not on probation or parole. He lives with his girlfriend and her son. He has a baby on the way. I respectfully ask the court to consider a personal bond.
Thank you. DDC's bond on your hold.
No holds, Your Honor.
Thank you. Council Court takes into account representation, including your client's significant family residential ties to the community. Further, taking the pandemic into across the nation as a factor, as well as these being non-assaulted charges. As in this case, the court will set binding amount of $2,500 personal bond. Is there anything further? Okay, you're all set, so you can step away from the camera.
Okay, this way, Doc. Thank you.
Yes, sir. Hi, your name, sir?
Childs.
Okay, calling. Okay, Mr. Childs, before we get to your case with your attorney present, we are going to cover a traffic misdemeanor ticket. This is a case where you missed a court date, so we're going to get you a new court date on the traffic misdemeanor. And when you do attend the next court date, it will be by Zoom conference, which is the video teleconferencing technology that we're using today. You're going to receive instructions on how to join your court date with your judge by Zoom. Do you understand? Okay, calling case number 204-93914, Peterson, Michigan versus Brandon Childs. Sir, you are charged with misdemeanor count 1, no operator's license on person. The ticket is a misdemeanor. The penalty that you could receive is 93 days in jail and or a $500 fine. Do you understand the charge and penalty you could receive on the ticket?
Yes, ma'am, I do.
Okay, call enter not guilty plea on your behalf. There's a Zoom pretrial date set for May 11, 2021 at 8:30 a.m. to 36th District Court in front of Judge Kenneth Johnson. With any criminal matter, you have the right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You also have the right to an attorney. If you cannot afford one on your own, the court will appoint one for you at public expense. Do you understand these rights?
Yes, ma'am, I do.
All right, and at this time, the warrants are set aside and that bond is continued. Also calling case number 2004-5859, Peterson, Michigan versus Brandon Childs. And counsel, your appearance, please.
On behalf of Brandon Childs, we have reading understands constitutional rights.
Call away the formal reading enter not guilty plea on your client's behalf. There's a Zoom pretrial date set for May 3, 2021 at 8:30 a.m. to 36th District Court. And it will be in front of Judge Austin, Garrett, and Esteban.
Mr. Childs is 30. Mr. Childs, sorry, is 31 years old, lifelong resident of Michigan. Yeah, knows that he now on probation or parole, will be staying with his mom, understands the no contact order, Your Honor. This incident appears to be from September 10, 2020, so it does have some age to it, Your Honor. He does have high blood pressure and heart disease. It appears he was never arraigned on this matter. He did not indicate his history. This is charged as a misdemeanor, Your Honor. I respectfully ask the court to consider it personal law.
Thank you. Did you see the bond on your hold?
No hold, Your Honor.
Thank you. Counsel Court takes into account representations, including his ties to the community, and also you proactively addressing your office, proactively addressing what's going to be no contact order while this case is pending, and also the pandemic facing the nation. Given those elements, court will set bond in the amount of $7,500 personal bond while this case is pending. Absolutely no contact with complaining witness Ashley Marie Lander. No contact means no written or verbal communication with this person, no messages to her through third parties, no contact orders extends to her place of residence and place of employment, and no social media contacts directly or indirectly. Is there anything further? Okay, you're all set, so you can step away from the camera.
This way, BC. Okay, thank you. Have a great day.
Yes, sir. Hi, your name, sir? I'm sorry, your name, sir?
Dayton Taylor. Like Dayton, Ohio.
Oh, Dayton, got it. Thank you, sir. Calling case number 210-57154. Peterson, Michigan versus Dayton Taylor, counsel. Call away the formal reading, enter not guilty plea on your client's behalf. There's a Zoom probable cause conference date, April 26, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date, May 3, 2021 at 9 o'clock, 36th District Court in front of Judge, I believe it's going to be McConaughey, and that's Devon.
He's 20 years old. He has no priors, not on probation or parole. He He's unemployed at this moment, but he does live with his mother and siblings. He's got very strong family ties. He did agree that he's going to be seeking his GED, Your Honor, because he just has a couple classes left. So respectfully, asking the court to consider a personal bond if he's not involved.
Thank you. Did you see his bond attorney Holt?
I don't have his folder, Your Honor.
That's fine. Thank you, ma'am. Just update us when you can. All right, counsel, court takes in account representations, including this is non-assaultive, the pandemic facing the nation. Also, that your client is availing himself of opportunities in the community to put himself in a better position. Given those elements, court will set bond in the amount of $2,000 personal bond and no firearms while this case is pending. Is there anything further? Okay, you're all set, so you can step away from the camera.
I don't have the folder. I don't even have his case sheet. No, I don't have. Thank you.
Sit right there by the fence. Right here.
Okay. All right.
What's up with that white black line across this first class?
Hi, your name, sir?
Yeah.
Okay, thank you. Yeah, keep the mask on so we can hear you. That's just for your safety while you're there, sir. Calling case number. Calling case number 3600-66865, People State Michigan versus Chioke Bunches. Counsel.
Mr. Chair, on behalf of Mr. Bunches, who is for more reading, understands his constitutional rights and sentencing.
Call away the formal reading, enter not guilty plea on your client's behalf. Counsel, the court is prepared to set dates. However, let's address something. This is an older case, it's significantly older. However, there are a couple of factors that this court would be interested in addressing. Let the record reflect the review of the file shows that on April 16 of 2001, the client failed to appear for a jury trial, which time a capias was issued and bonds in the amount of $5,000 cash as issued by Judge Azetta Bright. So this is an older matter, but for whatever reason, this court has not seen your client in pretty much 20 years to the date.
And Your Honor, I did speak to Mr. Bunch, and unfortunately, this case is over 21 years old, Your Honor, so Mr. Bunch could not remember what happened that day. He wanted to be honest with me. He didn't want to leave something up. He said, didn't recall. But I do have the information on him now, Your Honor. This was charged with misdemeanor. He has no priors to my knowledge. He is unemployed. He's not on probation or parole. He does not have contact with the complaining witness. I did talk to him about Zoom. I did make sure that he had something to help him with that because I have 2 kids. He said he's going to talk to one of them because he heard about Zoom, but is not familiar how to use it. We did discuss that he has to talk to his family. He does suffer from high blood pressure. This is allegedly 21 years ago, and it is a misdemeanor. So I understand the court's concern. However, he's 44 years old now, Your Honor, rather than 23. And Mr. Bunch wants to take care of this matter, Your Honor. It doesn't affect the student. I believe the court does have the authority to.
So noted, and the court appreciates. I'm sorry. Did you see if you have the information? Is the binds or any holds?
He has 1 hold, Your Honor.
Thank you. Okay, counsel. Again, this court is prepared to lean toward a great deal of leniency to allow your client to come back, but it's a little peculiar that it's been 20 years further, and again, the court is not looking to sandbag you, but a review of the file as you were making representations shows that your client was at some point clearly aware of this case, because it appears that was at a time when the domestic violence intervention program was in place. Your client attended that program. Further, it was the case that your client was cognizant enough back in 2001 to prepare for a jury trial. He asked for a jury trial. So the presumption is that on the day of the jury trial, your client, knowing that he specifically asked for a jury trial, that means that resources were garnered The judge was prepared, the prosecutor was prepared, the people were prepared, witnesses were prepared. Not only that, but a jury trial means that members from the community were brought in specifically for your client for the purposes of, and everybody was ready for a jury trial, and your client failed to appear. This was back in April 20 years ago.
And I understand, Your Honor, and I can't speak to what was happening during that time. I have candor on this with the court. Obviously, did not represent him at the time. We do represent him now. I just speak to him again, did not remember what happened that day. So all I can say is moving forward, that he needs to put this behind him, needs to take care of this. Again, his kids are ready to help him with the Zoom. He understands now the seriousness. Again, Your Honor, not making excuses, but now he's 44 rather than 23 and
So noted. Thank you, ma'am. And the court appreciates your candor, and the court is not holding your feet to the fire. The court is simply making a record because it's rare these days that we're getting cases that are this old. And it would be one thing if your client missed his court date within the last 18 months because of COVID and the complications that everyone has faced regarding that. But a review of the file shows that your client at some point was clearly aware that there was a case open and pending, and specifically at some point your client specifically asked for a jury trial. And those are resources that, you know, that the court was making available so that your client could be heard on this case and have his day in court, and for whatever reason, your client did not appear. So this is not for the purpose of addressing anything that your office has done. You've done an excellent job of addressing it, but this is just so that Mr. Funches that his memory gets refreshed, and also he needs to understand that the court goes through all of this so that people, members of the community, have their day in court, that they can be heard. And at some point, your client was cognizant enough of this case to say, I want to be heard, I want my day in court. And then when his day in court happened, he did not appear. Everybody was ready and he did not show. Bottom line. Further, it is the case that this was a misdemeanor matter. Further, it is the case that had your client appeared, and again, the court is not addressing this directly to counsel, had your client appeared, this would be long in his rearview mirror. And he'd have even more of a legitimate reason to just say, oh, you know what, I forgot this even happened. And there are very few excuses, because the review of the file is clear that he was aware enough that there was a case pending, open and pending, and he made choices and did not appear on his day in court.
And Mr. Funches heard the court, understands the court, understands what happened back then, what needs to happen going forward. He's shaking his head, Your Honor. I just ask the court respectfully to give him a chance to be able to get out and take care of this matter, Your Honor.
Thank you. And again, the court did that for the purpose of making a record so that the gentleman understands that this is an open and pending case, and he needs to show up. And if he fails to show up, he's going to run the risk of getting, there's going to be another warrant issued, and he's going to get picked up, and he's going to spend, you know, he could spend the rest of this case in custody until it actually does get to the final disposition, whatever it may be with this case. Here's what the court will do. And the court also appreciates, counsel, your office taking the steps to explain to him that, again, you know, circumstances are very different. We're all facing different sets of circumstances, including the pandemic, and therefore he needs to be prepared to be present in court, and he can avail himself of resources that are available to him by means of family and friends who can help walk him through this, because it's just as important for him to appear in court for this case as if it was 20 years ago, if not more so. Because this is an opportunity for him to get this case finally in his rearview mirror, whatever it is that happens, but that does not happen unless until he appears in court. Do you understand, Mr. Funches? All right, counsel, here's what the court is going to do. Court is going to set bond in the amount of $10,000 personal bond, and because this case remains open and pending, your client is to have no contact with the complaining witness. Stand by. Misha King, no contact means no written or verbal communication with this person, no messages to her through third parties, no contact or also extends her place of residence and place of employment, and no social media contacts directly or indirectly. Now, counsel, again, for the same reasons the court has indicated, the court is making the assumption, or it would be very advisable if your office has access to his current address or contact information. That would be extremely helpful, because then we can update the file and make sure that information is in the file to help eliminate any concerns about him receiving proper notices related to this case.
And yes, Your Honor, I've already provided that.
Okay, thank you. Let the record reflect that the court does have access to Mr. Funches's updated information. The court has indicated its bonding conditions. The bond, the court is not going to impose a tether, so hopefully $10,000 hanging over his head in order to secure his return will be enough to remind him that he needs to make this case a priority, and he needs to keep going back until a judge tells him that he's done with the case. Mr. Funches, do you understand, sir?
Yes, ma'am.
Okay, counsel, is there anything further? Okay, you're all set, so you can step away from the camera.
What was this court date, Your Honor?
I'm sorry, ma'am. It's going to be May 7, pretrial date May 7, 2021 at 8:30 a.m. in front of Judge Austin Garrett. Thank you, ma'am. Hi, your name, sir?
Flores Wagner.
Thank you. Calling case number 210575152, People State Michigan versus Florence Wagner, counsel.
Sean, on behalf of President Mr. Wagner, who is formal reading under advances constitutional rights and standing.
Court waive the formal reading is for not guilty plea on your client's behalf as a Zoom. Probable cause conference date May 10, 2021 at 8:30 in the 36th District Court, followed by a Zoom claim examination date to be determined in front of Judge King and as the bond.
Mr. Wagner is 17 years old. He has no priors. He's still in high school. He picks up jobs on the weekend with his friend's dad to stay out of trouble, even though he's never been in trouble, Your Honor. He lives with his mother and his sister. I did speak to his mom, who I believe is watching on YouTube. She's waiting for him, Your Honor. She did let me know that he's never been in trouble before, that he hopes he will get out today because he has ACTs on April 14th and his SAT on April 13th because he is preparing for college, Your Honor. So I respectfully ask the court to consider a personal bond.
Thank you. And did you see his bond or any holds?
No holds, Your Honor.
Thank you. Counsel court does take into account your representations, including your client's significant family and residential ties, including tremendous family support, which the court does appreciate seeing. Further, the court also takes into account that this is not it does not involve civilian complaining witnesses. And further, of particular note, the court certainly does appreciate that your client has a lot on his plate and a lot of good opportunities laying in front of him. And if the court may just briefly address in general, that given that your client has so many good things going for him, that to his benefit, one, that he's preparing to lay the basis for a future and a career for himself and to be able to pursue his educational opportunities. Now, he may or may not be at the point of applying, or whether or not he's applied and been accepted, or what he knows whether or not that status is. But one of the really important things at this stage is that the likelihood is very high that at some time in the near future, your client is going to have an opportunity to position himself to make the best out of the situation and to put himself in a position so that he does not have a record. If it is the case that he has no prior convictions, it is really essential. He must recognize, and hopefully he will come to recognize, that he is a tremendous asset. He is a commodity in this community, in that he is a young African-American male with no record. And if it is the case that he comes up with an opportunity or is presented with an opportunity to keep anything off his record, he wants to take advantage of that. Now, whatever decision he wants to make is entirely up to him. But considering he has so many good things going for him, he will benefit tremendously from not having a record. Because whether it comes to loans, student loans, going to a bank, applying for a job, applying to school, often any of those applications will ask, have you ever been convicted of a crime, yes or no? And the answer to that question can often distinguish a person on the opportunities that are in front of them. So considering your client has so many good things coming on the horizon, it would be to his benefit, either with your counsel from your office or with his attorney of record at the next court date, to help position himself so that he can take advantage of all those opportunities. Because if he is an individual who can get through life without a conviction, he will stand head and shoulders among his peers. And it is absolutely essential. This court does not take the time, doesn't necessarily go off script and spend this much time speaking on the issue. This court is not looking to be preachy, but your client should come to understand and appreciate what a commodity, what a valuable individual he is. And he's going to want to take advantage of any opportunity to make sure he does not have a record. That is essential at this point. Counsel, is there anything further?
Thank you so much for that, Your Honor.
Okay. Here, briefly, here's what we're going to do. Again, probable cause conference date May 10, 2021, in front of Judge King. And this court is confident that Judge King is probably going to reiterate the same message to him. Judge King will be very interested and would certainly welcome an opportunity to hear about all the good things that he's doing. So here's what the court is going to do. The court is going to set bond in the amount of $2,000 personal. Anything further? Okay, thank you. You're all set, so you can step away from the camera. Oh, I thought, was it Rojas or Martin? I thought it was defendant.
So Rojas has the case counsel, and it should be correct.
Okay. Well, he hasn't checked in just yet. We're going to keep the room open. So here's what we're going to do, since that's the only case left on the men's side. Did you see, we're waiting for a retained attorney for Mr. Rojas. In the meantime, if you have the ability to do so, we can join you on the women's side and take care of the Allen case.
Okay, Your Honor.
Okay, thank you, ma'am. We'll see you on the other side.
Okay.
So you gonna step in that black box for the first and last time?
Can you pass it to the sanitary now?
Hi, ma'am, your name?
Michelle Allen.
Okay, Miss Allen, stand by. We're going to have your attorney join us in just a moment.
Okay.
The gentleman time on behalf of Ms. Allen with formal reading under federal constitutional rights and standards.
So noted. Thank you. Calling case number 20044397001, people say Michigan versus Michelle Allen. The court will hear the formal reading, enter not guilty plea on your client's behalf. There's a Zoom pretrial date, May 7, 2021 at 8:30 a.m. to Thursday District Court in front of Judge Bryant and as the bond.
Ms. Allen turned herself in this morning. She found out about this, applying for, she's a foster mom. She takes some foster kids, Your Honor. And she, as soon as she found out about this, she turned herself in. She wants to take care of this as fast as she can, to get clearance, Your Honor, and continue to do what she does. Respectfully, to consider a personal bond. This incident is from 2019. She does have her GED. She's not on probation or parole. She had 2 kids. One passed away. She lives with us. We're foster kids, Your Honor, and I don't believe she's at flight risk since she's got great community ties and she turned herself.
Thank you. All right, counsel court takes account representation, including this is an older matter. It appears the parties are unrelated to one another. And the court also, most importantly, gives great gravity to the fact that the client did turn herself in to make herself available for arraignment to this court, plus her significant ties to the community and that she's looking to contribute and make and do good things for people in the community. Given those elements, court will set by an amount of $1,000 personal bond. And because of the nature of the charge, no contact with complaining witness Sharame Settle. No contact means no written or verbal communication with this person, no messages to her through third parties, and no contact or also extends to a place of residence and place of employment, and no social media contacts directly or indirectly. Is there anything further? I'm sorry, court date is May 7, 2021 at 8:30 a.m. to Thursday District Court in front of Judge Bryant. Anything further? Okay, thank you. You're all set, ma'am. Step away from the camera. All right, Council Cripps, we're going to go back over to the men's side in just a moment and let them know that you're here.
Thank you.
Your Honor, I apologize. I was untold, Mr. Cripps.
Oh, no, that's fine. No, thank you for being able to get them updated. So we've got everybody. And Mr. Cripps, while we're waiting to get on screen. Hi, DDC, we're back. We have an attorney here for Mr. Rojas, if you can make him available. Counsel Cripps, if we can get your P number for the record.
P34972.
34972. Thank you.
Thank you, Your Honor.
Now we're just waiting for you. Yes, sir. We're just waiting to get your person on screen.
Pull it over your nose. Thank you. See you coughing already.
Okay. All right. Counsel, we're ready. Calling case number 2006241, People State Michigan versus defendant number 2, Anthony Dean Rojas. Counsel.
Good afternoon, Honor. David Cripps, P. 34972, appearing on behalf of Anthony Dean Rojas. He would stand mute, waive the reading and complaint warrant.
Go with the formal reading of your not guilty plea on your client's behalf. There's going to be a Zoom probable cause conference date May 10, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom clear examination date to be determined. Also by Zoom at the 36th District Court in front of Judge Joe and Esteban. Esteban, counsel.
Thank you, Judge. This is my client's second time turning himself in. The first time he turned himself in, I believe it was a couple weeks ago, they rejected him because he was positive for COVID-19. I do have a report from Northwest Labs in Southfield that confirmed is that on March 7th, he had a positive result for COVID. So obviously, I'm asking for a personal bond related to his medical condition because we certainly don't want him in the Wayne County Jail with a COVID positive showing. He has suffered third-degree burns on 30% of his body due to this incident itself. He was in Detroit, Henry Ford Hospital for a period of time due to those injuries. He has suffered from pneumonia also since this unfortunate incident occurred. He would live with his sister, Maria Schollenberger, at 35965 Scone. I believe that's spelled S-C-O-N-E, in the city of Livonia during the pendency of this case, Your Honor. I did confirm that with his sister. So I'm asking you, in light of his medical difficulties, to consider a personal bond, please.
Thank you, counsel. And DDC, is the bond, are there any holds?
He has holds, Your Honor.
Okay, counsel, let the record reflect the court does appreciate a number of factors. One, that you've been working with Mr. Rojas for him to turn himself in, and again, for reasons at no fault of his own because of the pandemic facing the nation. The court appreciates that you were working with your client to make sure that he was mindful and was able to exercise as many COVID conscious protocols as possible, and also and still make himself available for arraignment to this court. Also for the other medical reasons that you've indicated, and again to ensure safety of the community, including the population at the DDC, as well as to your client, so that he can maximize his efforts to keep himself safe and well. Court on this case is going to set bond in the amount of $7,500 personal bond. Also, court is going to mark the file medical. Just to clarify, counsel, and again, the court is not looking to have your office disclose any personal information, but is it the case that potentially he could still expose people, or is he well enough at this time? I guess the question is whether or not, if it's possible that he's an exposure risk. The court is going to post a bond, but part of the concern also is that if he has holds, the court has no control over that, in which case the court would simply mark the file medical with regard to COVID in addition to his physical injuries.
Thank you, Judge.
So you would want to mark the file
yes,
for that reason? Because we're just looking to make sure so that if the DDC or any other agency needs to take precautions, they're aware, and that would be on his minimus, just to make sure everyone's safe.
I would like a marked medical just to protect anybody that comes into contact with, potentially could come into contact with.
Okay, then the court will do that.
Man, he sees I'm doing something. I'm gonna stop what I'm doing, and I gotta.
Okay, counsel, again, bond is $7,500 personal. The court is marking the file medical for the reasons indicated on the record. With regard to his positive status in the last several weeks, does that cover everything, or is there anything further?
No, Judge, and you said the next date is May 10th, correct?
May 10th, yes, for probable cause.
Thank you very much, Judge. I appreciate it.
Okay, thank you. We appreciate your assistance. CDC, we are concluded with regard to Mr. Rojas. I think that's everything at this time. Thank you. CDC, we'll see you next week. Thank you.